If an ex-employee violates one of the employment agreements, you have three options. First is do nothing. Let's assume that's not a real option for you. The second option is contact the person. Try to speak with him or her. Find out if what you think they did, they actually did. Quite often, the reality is somewhere in between. But let's assume you find out they are violating the agreement and you can't work it out. Your third option is to sue them. So assuming you do sue them, what are your options? What are your remedies? What can you get? The first one is monetary damages. That's just money. And you can get it from two ways: the business you lost or the business they improperly obtained. The second is what's called liquidated damages, and you can plan ahead for this. You can put this in your agreements, that if the agreement is breached and because damages may be uncertain or hard to prove, that the person is liable for X amount. Now, what is X amount? It has to be reasonable, and it has to be specific to your industry or type of work. A third type of damage doesn't involve money. It's called an injunction. You've probably heard about that. An injunction is a court order generally prohibiting someone from doing something. In this case, it would be prohibiting someone from violating a non-compete or a non-disclosure agreement or something like that. If the person violates that injunction or court order, they'll be held in contempt. And if you get held in contempt, the very next step, if you don't comply quickly, is a bench warrant will be issued for your arrest. Now, a final remedy you can add into all of this or any of your agreements is attorney fees. You can put in your agreement that if there's a dispute about the agreement and it goes to litigation, that the prevailing party will be entitled to an award of reasonable attorney fees. Now, what is that amount? That's a complete unknown. It could be anywhere from the amount of the underlying damages or harm to 10, 20, 30 times that amount. But again, that's a prevailing party provision, and it works both ways. You have to keep that in mind. So these are remedies that you may be entitled to if the person breaches the non-compete or any of the employment agreements.